Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
We got Kimball Jones with us here today, all the way from right down the street in Las Vegas. So pretty stoked about it. Kimball's been on a little bit of a tear and in the courtroom, and that's where we're about to find out how Kimball went from being a bank clerk to a trial lawyer, the unlikely journey. So Kimball, tell us, because everybody becomes a lawyer for different reasons, and but yours is more basic. So give us an idea when you thought, you know what, I think I'll become a lawyer.
Nobody in my family had ever been a lawyer, including extended family. I'm the youngest of 12 children, so I had a whole bunch of family members that did all sorts of things in medicine and different areas, but nobody had been a lawyer. The things that the rest of my family was doing, none of those things sounded like what I wanted to do. And when I was in undergrad, getting my bachelor's degree, I pretty much looked up careers that made money that were not in medicine, and being a lawyer looked like a good one. That's what the numbers told me. And I had grown up very poor. We lived in a mobile home in Arizona, and I didn't want to be poor. So I chose a career that looked like it was going to provide a good income. So that was pretty much it. That was kind of my thinking. And so I found out I needed to take the LSAT, took the LSAT, did pretty well. I had gotten pretty good grades in undergrad, so I went to law school. That was pretty much what it was.
And you went to BYU.
I did, yeah. So
what was behind that choice?
yeah, so I grew up Mormon. I went on a Mormon mission, spent 2 years in Peru before I went to college, and that was a really, really cool experience. I came back, I really had an appreciation for what we actually have in the United States, the opportunities and everything. It was really mind-blowing seeing how difficult it is in other places. So I came back and I had never been a good student, but now I understood that I had a huge opportunity, having kind of seen what it's like to live in Peru. Anyway, so I was just highly motivated. So I went to BYU, Idaho. It was the only school I even applied to. That's where my parents had gone. And then I went to law school at BYU. I applied to a whole bunch of different schools, did not actually even apply to BYU. And then they came and recruited me because someone at BYU Idaho said I was this good student. So they gave me a nice scholarship. So I went to BYU, and I hated law school, all of it. About 2 weeks in, I realized, man, this is about as boring as anything can be. It's a history class where you focus on a bunch of cases and different subjects. Probably about a year in or less, I stopped buying books. I would get outlines and cram for tests, and then I mostly would play video games. But I did not enjoy law school very much. And when I did clerkships, I worked for these corporate or real estate firms, and I hated that too. I hated my summer clerkships. I felt the work was boring. I had done roofing, I had done insulation, framing, worked at Burger King. I had been a server. I had all these jobs growing up, and working as a clerk in a law firm was the job I liked the least of anything I had ever done. And so I came out of law school thinking, even if it pays well, I can't survive this. This is just too boring of a job. And so I went into banking initially, which was in 2008 is when I graduated. And the opportunities were not great, but I did pretty well there at Chase. And on the side, I ended up signing up for the Army through the National Guard just as a reservist, a weekend warrior type. But then I ended up taking on a bunch of active duty assignments, getting some additional training, and kind of made that an active duty career for a period of from about 2009 to the end of 2012.
Okay, so the banking, how long were you a banker for? Because, you talk about boring, that sounds horrifically boring.
I felt it was, at least I didn't have to bill my hours, right? I didn't have to count every 6 minutes of my life. But yes, it wasn't the most exciting thing. So I was a low-level banker at a bank. It was in the Chase building, the JP Morgan Chase building in Salt Lake, and I was on the bottom floor there, selling people financial products, basically. And so I did that for about a year.
Tell us about your military service. At least as much as you can mention, because it's pretty interesting, I think. And I think it's good training for becoming a lawyer
It was awesome.
for what you were doing now.
Yeah, I loved the military service. That's really why I switched over from banking. When I would go do military things as a weekend warrior type, I just enjoyed it so much. The camaraderie, the purpose, it felt more meaningful to me. And so I decided to go and become an officer, went to officer candidate school. Then I became a counterintelligence special agent and had a top secret clearance and kind of worked in that world for a little while until about the end of 2012. And you can't really, talk too much about the things that you do. It's actually less exciting than what people imagine, but it was a great experience, and I really did enjoy that time. That was really good. And I
But the fact that we can't talk about it makes it sound more mysterious and exciting, Kimball.
totally, yes. So, and I lean into that, right? Yeah, I can't tell you about it, guys. So that must mean it's cool, right?
Absolutely, absolutely. So you did about 4 years of your military service, and your brothers both just recently got out of the military, did they not?
They did, yeah. So, two brothers, they both also were in intelligence. They did a lot of cool stuff. They actually served much longer careers, much more dangerous careers. Both of them spent quite a bit of time in Iraq. My brother Danny he did maybe 5 separate deployments, and we're talking like year-long deployments. So yeah, those guys are the real deal, and they both just got out and transitioned, finished law school last year. Yeah,
That's pretty exciting. Now they work with you over at Bighorn Law.
they do.
Those are your older those are your older brothers. So
Yeah. Yeah, they inspired me to join the military, and then after I got out and I figured out what being a trial lawyer was a little bit, or I had gotten my feet wet, I just started immediately sales pitching them as hard as I could. Hey, you got to get out and you got to come join me and do this. This is great.
and they listen to you, which is amazing because sometimes big brothers don't always listen. My brothers often didn't listen to me, even though I was always right. It was weird how they wouldn't listen, but so that was good. You were able to convince your brothers. So 2013, you said
Yeah,
we're done with our deployment, with our military career.
full time. I continued to be in through the end of 2015 as a reservist. So, and I'll tell you, trying to be a trial lawyer and being a weekend warrior at the same time, that was pretty rough because you know how hard you work. Monday to Friday, I'm working 12, 16-hour days, and then I go and I'm in charge of a platoon, or I'm the number two in a significant organization, and and I'm working day and night. So you have these 12-day stretches every month that are just brutal. You have no time off. And so at the end of 2015, my wife convinced me that I should give up the military, and I did. So December of 2015 is the last time I went to any weekend stuff.
So how did you get back into the practice of law from being in the military?
I was on orders, right? And as you're on orders, you go through those orders. And so I had orders that ended at the end of 2012. And our oldest son at the time was just in school, and we found that he had a tough time adjusting to the moving that was required with the military, and I was going to have to move again under all circumstances that we were dealing with there. And so we decided that, you know what, let's go and give law a try. And the reason that we really did it was because my good buddy from law school, Ryan Anderson, he was doing really well in law, and he had just gone out on his own, started his own firm. And I didn't expect to necessarily work with him, but he told me what he was doing in Vegas, how he was going to trial, how he was in court almost every day, settling cases with insurance companies, negotiating. It all just sounded fun to me. And I thought, man, I think I'd be really good at that. That doesn't sound anything like those boring clerkships I did. And so we moved to Vegas, and my family stayed with her family, with my wife's family, for like a couple of months while I studied for the bar. And so beginning of 2013, we're in Vegas, took the bar, fortunately passed, and then we started running. And Ryan Anderson did hire me. I was his second associate. His first associate quit like a month after I was there or something. And then Jackie Bertel, who is my partner here at Bighorn Law, she joined a few months later, and it's just been an amazing team. So
Yeah, you really do have quite the team there because Jackie is quite the business operations guru. I've seen her present. I'm rarely impressed, and I was very impressed. But just to be clear, you got out of law school in 2008, but you don't decide to sit for the bar exam until 2013.
February 2013 bar exam. So
I think I might have taken the same one in
yeah, good.
California. Around that time, I think I.
Yeah.
No, I didn't pass. I took it, but I failed that one. And I failed the next one after that. It wasn't until about 2015, after about 4 tries, I finally passed. But
Well, you got it
oh, I
done.
got it done.
That's
People, what are you
awesome.
gonna do if you fail? I'm like, take it again. They're like, how about if you fail again? I'm like, I'm gonna take it again. And
Hell yeah.
it was like, to me, it was like incredulous that somebody would like actually consider quitting after failing. Like, like why would you quit? What are you gonna do? Like, you know what I mean? Like quitting, you have no chance. I mean, it kind of sucks sitting for the bar, studying for the 4th time, and being 48 years old or whatever it was. But the reality is, like, it's a great opportunity, right? I mean, how many people get to sit down and just sit and study for 2 months and get to focus? Not everybody. So, and it took a while. I had to get a tutor, but we got through it, importantly. But you finally get your bar card. So tell us about how it is that you finally start getting into the courtroom and to develop it as a trial lawyer.
In the very early days when I started, I think that our firm, although Ryan Anderson, he had actually had some verdicts in trial. He never lost. I think he was 7-0 or 8-0 as a first chair trial attorney. But the largest verdict he had was, I think, $700,000 or $800,000. It was just below $1 million. Really good job on a very difficult case. But our firm was kind of resistant to going to trial a little bit. It was kind of viewed as a high risk proposition. So I handled a ton of cases, was litigating a huge caseload while handling a big claims desk at the same time. And I mean, I was just kind of working day and night, just moving through case after case after case. And it really helped just kind of being thrown into the fire that way, just to understand the variety of things that can happen in cases and in litigation. I got a ton of experience just in seeing ideas and how things could be framed in the context of a case. But ultimately, when I was about a year in, I had a guy come to the office one day, and he had been dropped by like 5 attorneys, and he had a short trial. It's a thing we have here in Nevada, where it's a 1-day trial with 4 jurors, and he asked if we would take his case. And so I begged my boss, Ryan, to let me do it. He let me do it. Jackie Bertel did the trial with me. We went up against a guy named Bruce Dickinson, who's a very good trial attorney on the defense side. I think we put on a hell of a case. We didn't really know what we were doing. Jackie understood what she was doing better than I did. I probably did perhaps the worst direct examination that has ever been done in the history of direct examinations during that case. And I did perform a pretty solid closing argument, I thought, but we lost, got defensed. And so that was probably in the end of 2013. And so I was a little bit upset about losing, but that was the first time in the courtroom. And then the next time I got in, it was 2 years later, probably 2 or 3 years later. I took a case that had 23,000 in meds, and we ended up getting a win on the case, but barely. The jury awarded literally $1 above my client's past medical bills, and that was the jury verdict number 2.
All right, so we learned how to get our medical bills and our economics. That was good, but really didn't really able to communicate the pain and suffering yet. So, building upon that, the first win was the next adventure.
Yeah, so I definitely realized that I had no idea how to increase to get fair value in a case. I was starting to figure out how to win a case, but I didn't understand how to really get value in the case. The next case I did was this disputed liability tough case that we had lost in arbitration, and we did another short trial. I won. We got like $11,000 or something dollars, not very much. And then I had a big case that could not lose. I had $900,000 in meds. It was a massive rear end collision. Back end of my client's car is gone. There was kind of an unsupported claim of a lane change at the last minute, but it was very weak. And my client had multiple brain surgeries. His name was Caesar, just an amazing guy. He was an immigrant from Mexico, spoke beautiful, perfect English as well as Spanish, of course, and just a wonderful guy. He was gay, he was married, and the case was just couldn't lose. It was this beautiful case. And I knew that I didn't have the skill to do it. I had not been in a big trial yet. And so I brought in somebody who is really an amazing trial attorney. He is an amazing trial attorney. He's a very good friend of mine, David Churchill, and he came and did it with me. David had at least 2 7-figure verdicts that same year before we did this trial. And I think he has more than a dozen 7-figure verdicts. This is a very good trial attorney. And we did the trial together. And it was a case where, for the first time in my career, I felt totally ambushed by the judge. The judge was clearly in favor of the defense and took many, many measures to hurt our case along the way, including interrupting constantly while Dave was doing jury selection, and even during opening, cut Dave off when Dave was maybe 45 minutes into his opening, just like shut him down and like stop the opening. Just some really incredible things. But as we went through the trial, the evidence came in beautifully. We established our case. We knew we had demonstrated our case and that we had a winner. And the verdict came back and we got defensed. It was gut-wrenching because we knew that our case was righteous, that our client was just so deserving. And so we talked, the jury was split. It was a jury that deliberated for like 3 days. And it ended up splitting 6-2, which is what you need for a verdict. And apparently it had been split 5-3, and then one of the jurors switched sides just to get the case done, basically, because she didn't want to be there any longer. And the foreperson said that in the jury room there was a bunch of misconduct. She came and talked to Dave and I, including people saying that our client's brain issues probably related to him being gay, as opposed to the crash or something weird stuff like that. And people didn't want to award money to our client because, you know, his injuries were pretty bad and he might die, and they didn't want the money to just go to his mom in Mexico. And so this is just in 2018. This isn't very long ago, but it was pretty amazing. We appealed the decision and we ended up losing the appeal. You know, my client Caesar, this is, you know, a case that will stick with me forever. My client Caesar, he died from the injuries in this crash at the end of the appeal around that time. And I was there with him in the hospital while he's on all sorts of tubes and everything. And he deserved to win, and his family deserved for him to win, and we lost. And it was gut-wrenching. I didn't sleep well for a couple of months.
I can imagine, because I know what it feels like, but you never really know what it feels like until you're just in it. You know what I mean? You can imagine what it feels like, but until you feel it, it's just not the same, because it's horrible, especially when somebody's so deserving, so catastrophically injured, trusted you, put all their faith in you, and, you know, you let them down. You tried your best, but it doesn't matter. Trying is useless. You have to, winning is where it's at. I'm sorry. In the courtroom, there's no second place. And so how did that loss, tell us about the after effects of that loss.
You know, it was, people talk about being able to learn more from a loss than a win. There's no question that's true. I do my very best to work hard to learn from my wins, but that's hard. It takes real effort. This, I just couldn't sleep for a couple of months, right? And so every night I'm thinking, I wake up in the middle of the night at 3 a.m., and I'm just thinking, oh, why did we do this? Oh, this one moment when this happened. And so every little issue, you second guess it. And frankly, it helped me refine my thinking on a number of things, that I changed the way I do things. And so there are things very specifically, I'll just give one quick example, right? So in the case, we stipulated to having all the medical records come in. The medical records were not bad for us. They were good for us. But if taken out of context, they could, of course, be framed as being bad for us. And since we got so ambushed in jury selection, we didn't really win jury selection. And so I felt like the jury wasn't necessarily great. So if you have a jury who's looking to go against you and you have some garbage taken out of context from records, you can have problems. And that happened in that case. And so since that time, I rarely bring medical records in. I almost never do. And so we get to the pretrial conference and the defense says, why you only have like these 15 documents you're trying to bring in? and I say, yeah, that's all I got. And they are surprised. You don't want all the medical records in? Like, no. I mean, I want this image of the spine that's all jacked up. That's coming in. But no. And so I don't stipulate. So they end up having to bring in my client's own doctor to try to get records in or something. And so I've done that in most of my trials since that time. And that's just one little thing that I learned there, that why take the risk? Why let something be taken out of context? Let them do the work to try to get something in if it has a chance of hurting you. So things like that I've learned. But I did feel like I needed to get right back into trial, and I felt like I was good at trial. I came out of that trial feeling like I'm good at this. Like this is not a fluke. During that trial, I cross-examined a neurosurgeon, the defense neurosurgeon, and I destroyed him. It was one of my best crosses ever. And, when we got in the elevator, Dave is telling me, he's like, I'll tell you, like, I saw Egglet destroy some guy in a trial one time, 10 years ago. Other than that, this is probably the best cross I've ever seen, right? And this is my first big trial, right? And so I'm feeling really good about my abilities. So I push my way into another short trial, a one-day trial. We end up getting like 4 times meds, but I think meds were like 6,000 or something. And so we got like 26 or $30,000. And then I had a bench trial in front of Judge Hardy, and I got a really good result. Got like a $3 million result on a bench trial that same year. But a bench trial, of course, is very different than a jury trial. And so my first shot at another big jury trial, I had a good friend of mine, George Hand, is an attorney here in town, and he came to me with this case. And Tina, and she's just this amazing woman who went in for a hernia repair surgery. The doctor botched it, injured her colon, and ended up delaying treatment for an extended period of time. And she ended up developing bilateral foot drop as a result. This was a case that George, I think, had tried to take to Sean Claggett and to anybody else that would take it in town who would ever accomplish something in trial. When all of them said no, he brought it to me, and I was happy to take it because it was a case that, although it was difficult, I felt it was righteous and it had some upside.
How many med mal trials had you done before this one?
No, this was the first. I had never done a med mal trial. I'd handled a couple in litigation, like literally, when I say a couple, I think 2. So I had litigated 2 and settled them.
Do you think about how desperate George had to be to come to you?
Yeah.
I'm not even joking. I'm just
No.
saying. A guy's done one bench trial, got a good result, a couple small trials, loses a rear end collision.
Right.
Probably not going to be the top of the list for co-counsels, but tell us.
No.
Tell us, though, the adventure of this trial.
Yeah, so we got the trial and the entire focus of everybody, and we're only about maybe 2 or 3 months before trial when the case was brought to me, and the focus of everybody, all of the experts, was on the delay in care. But they had not deposed one of my experts, my surgeon expert, who had said that one of the breaches in the standard of care was intraoperative technique. That's very, very vague, right? And it can be interpreted as anything. And I noticed as I went through, the doctor probably shouldn't have been using a certain tool during the original procedure. He used something called a ligature. And in close proximity to the bowel, you can injure the bowel. But anyway, I thought that it made a compelling case that I could reframe the case at that point to say, no, this is a system failure. This is a careless, arrogant doctor who went in with a bad plan, used the wrong tools, and caused this cascade of problems because of that, right? Because of an actual choice that he made or a series of choices that he made, and take it away from the focus of the delay, which I felt was a loser. And so I focus grouped that. It turned out that ended up being what the focus groups tended to think too, that the case tended to not go very well when the focus was on the delay, but it tended to go well when it was focused on the system failure and choices preceding the surgery. So we did that. We reshaped it in that way. The defense took my expert's deposition. He nailed it, did a really good job explaining the intraoperative technique, including the use of ligature in this case was below the standard of care. And we went to trial, and it went amazingly. We ended up having a great jury selection, ended up having a great jury. We walked out of that jury selection, and we knew that we had a really, really good jury. And I barely...
Did you do the jury selection?
I did, yeah. Yeah, I did the jury selection. And, I insisted on it. I had 2 co-counsel, both of whom had more experience probably technically than I did. But I felt very confident about it. I insisted / begged and said, I really want to do the jury selection. And so they were good with that. And I took resources from everybody. Sean Claggett here in town took a bunch of stuff that he had done. I was listening to Mitnick's podcast every day and like writing down little things that Mitnick had done, the advice he gave in MedMals, and taking his little ideas and incorporating them. And yeah, I just used every tool that I had. A great book, by the way, that I have to give a shout out. It is The Medical Malpractice Trial. It's from Trial Guides. Oh, incredible book. I read that, devoured it, took a bunch of notes on all sorts of different parts of things that they recommended in that book.
Was that Kazaratsky that wrote that? Who wrote that book?
No, I don't have it in front of me, and I
Oh,
feel like a jerk. There's two
okay.
authors of it though. There's two authors of the book.
I was just trying to test my memory. Go ahead.
Yeah, one of the authors of the book won the Michael Jackson trial against the doctor, I believe, that was giving the propofol. I think. Anyway, something like that. Anyway, he was
I think Pat has
involved.
tried that. I think Pat has tried that case, and that was his last time he lost a trial. So,
I think there were like
on the,
multiple Michael Jackson cases, and
maybe who
this
knows?
was a med mal only portion. But anyway, but it's a really good book. It was very helpful for me. We ended up getting a $13.6 million verdict. We asked for 12.6 million actually, so we had like 5.8 million in specials. In closing arguments, I was too afraid to ask for a number, so I didn't ask for a number. And then the defense goes, and then in my rebuttal close, I go in with a little bit of authority, and I ask for my number of 12.6, and the jury comes back. And in Nevada, you can say send a message as long as you do it in the context of the case, right? So in my rebuttal close, I said you should send a message based on the evidence in this case that what he did is not okay, and you should send that message through your verdict. And I asked for 12.6 million. The jury came back with 13.6. The foreperson afterwards told me we felt like we should go above what you asked for so that the doctor understood we were sending him a message.
That's so great.
So, yeah.
That's what 2019.
Yeah, end of 2009.
All right, so you get on your finally, it comes together for you. 8-figure verdict, first one. Didn't even have a 7-figure verdict. Just jumped right to 8 figures. That's great.
Yeah, I didn't have a 6-figure verdict, Dan. My highest actual verdict was $26,000, I think, or 28,000. Yeah.
See, all that study you did paid off, and so you're on a roll now. 2019, fired up for your next trial, but you're gonna have to wait a while for that. Is that true?
Yeah, it was a major bummer. I had a trial. My client's name is Deanna, and we were like 2 weeks out from trial in 2020, and I knew the case we were going to hit it for 5 million plus. Like I knew that. Like it was such a good case, and also it was going to be validating for me because I didn't want to be a one-hit wonder. That got one verdict, and then COVID hit, right, and just everything shut down. So. Yeah, I did end up trying that case, but not until 2022. And we did get 8.9 million on the verdict on that one, but we had to wait a couple of years, and that sucked.
So as you waited through COVID, tell us about some of the things you did to get better so that when COVID broke, you were ready. Because actually you tried that case in October 2021. So it's like that's the same time we did the first TLU Vegas. So you see October 2021, big month in our lives.
Yeah.
But between March of 2020 and October of 2021, tell us the type of things that you're doing to keep your skills not just sharp, but to improve them so that you're ready.
Yeah, I mean, it was realistically, I mean, everybody remembers the insurance companies just stopped paying money on cases. I personally, on my desk, I didn't have a settlement between March of 2020 and December of 2020. So I settled a big case in March, and then I settled another big case in December. Not a single settlement on any case I was working on in that interim. So it was a tough time. But every day I'm watching your stuff, Dan. I mean, honestly, like TLU, your case analysis stuff, it just kept me floating, and I'm just developing my skills every day as I'm watching these great trial attorneys who I never had access to, and they're putting on these presentations. I mean, it was incredible. I mean, that really was the thing. And there's no way that I would be as good as I am today, whatever that happens to be, without you, man, without TLU. It's been even after COVID. Every time I have some new wrinkle in a case, I go on TLU on demand. I find somebody who's done a case like me before. I look at what they did. I pull their ideas. I mean, it is just a total game changer. It really has been amazing.
I really appreciate you saying that because obviously my goal is to create content that helps people. And when I learn about it helping people, it means a lot. That's all I can say. It means a lot to me. It means a lot to all the presenters who, took all that time and continue to take a lot of time because, we have this big event coming up, and I know that, people put a lot of time in these presentations. Like Joe Frieda, Satch Albert actually flew, from where they're at to each other to meet for a couple days just to work on their presentations. That's how serious they are about the presenting and the teaching, which is, obviously preparation for everything, whether it's a courtroom, a presentation, a podcast, a webinar. It's key to, putting your best foot forward and putting your best stuff out there. So 2021, you get your $8 million verdict.
You know, so I had in 2021, we got a $1.6 million verdict. That the $8 million ended up coming later. So it just, yeah, in 2021, the courts were basically still not open, but we had this one judge who's a phenomenal judge here in Las Vegas. Her name is Nadia Krall, tremendous judge, very, very sharp. We have a trial, we have like a calendar call, and we've been having these, but they're all getting kicked out. And we have this calendar call in September of 2021, assuming it's going to be kicked out. And she says, no, you're going to trial. It's happening. And everybody, the defense has excuses. And she's like, no, it's happening. Jury trial on this day, it's going. So not optional, you're going to trial. And she was not hearing excuses about it. And so we end up going to this trial we didn't really expect to go to, and with a few weeks notice. And it was a case where we had $32,000 in meds that we had waived, but we had a traumatic brain injury. There was a 3-year gap in treatment. I actually did a case analysis on it. It's the Tongle case, and it worked out really well. We ended up getting a $1.6 million verdict, and at the time we did the case analysis, nothing had been paid, but we won on the appeal, and they sent us a check this year. It was $2.7 million, and our wonderful client Gina got fair compensation. So that was awesome.
I bet. So after that, then you had your $8 million one.
Yeah.
All right. And so because we're taking the trial lawyer's journey here with Kimball Jones, because fortunately it was a relatively quick journey. So after that one, tell us about the next time in the courtroom.
Yeah. A few months after the $8 million verdict, we ended up having another case. The jury was going to come back with at least a few $1 million and got a mistrial against me. Judge ordered a mistrial against me for something that I did that I shouldn't have done. I told the judge, upon genuine belief, that there had been something that had been disclosed in the case, which had not been, and it was used as a demonstrative. And after it had been used as a demonstrative, it turned out it had not been disclosed in the case. It was a mistake by me, and the judge hammered me for it and did a mistrial. And it was the last day of trial, and the jury came in and talked to us. They didn't get to be told why the mistrial happened, and it's this excess case against Geico. And the jury tells everybody that, yeah, we knew the plaintiff was really injured. It was a 0 property damage case, but with legitimate injuries. And they're like, oh, yeah, we were going to give millions to the plaintiff on this one, and kind of criticized the defense attorneys and said they didn't feel like they had a case. After that, the attorneys moved for sanctions from the mistrial, and the judge said, no, nothing was intentional. It was clearly just a mistake. So they didn't get their sanctions, and then they paid a lot of money to not go to trial a second time.
That worked out.
Yeah.
Let's fast forward to about 45 days ago, or about 2 months ago, because you started a 30-day run where you did 3 trials in 30 days.
Yeah.
So, that's just hard to believe. So tell us about this run.
I'm cheating just a little bit. So I tried these. I filed these 2 lawsuits together that were part of one incident. So my client, wonderful guy Hal, gets hit in a marked crosswalk as he's crossing the street, and he is thrown 79 feet through the air, 13 broken bones, major injuries, survives somehow, goes to the hospital, is taken to the trauma trauma ICU. They do a ton of surgeries on him right off the bat to put him back together. He ends up getting out of the hospital in about a month, and his bill is $855,000. So he requests that we help him out, right? So we end up getting a call, and we meet with him, and we don't want to take a fee when the insurance should very clearly pay. So we just help him get letters sent out to the insurance companies, and that's it, and ask the insurance companies to pay him. And they don't. Both insurance companies mess around and they don't pay him. And so
how much were they supposed to pay him?
Yeah, so the at-fault driver had a $25,000 policy, and his own insurance had a $100,000 UIM policy, as well as $1,000 in med pay. And that's it. Just pay him. Those letters were sent out. At some point, he reaches out and says, hey, are they ever going to pay, or what's going on? And so we ended up getting involved, and we ended up taking the case and filed a lawsuit. And it's an idea that I've had. You can't do this in every state, but in states where the first party insurer has a duty to pay based on the value of the case, regardless of what the third party insurer does, what the at-fault insurer does, you can go after the first party insurer for breach of contract, bad faith. And that's what we did. So we sued the at-fault driver and sued Progressive Insurance, who was Hal's insurance company. And we sued them together. And then we went to trial. The trial judge, just tremendous trial judge, supreme control of her courtroom, always on time, always efficient, didn't let me do all the things that I'm used to doing because she has her rules in the courtroom. But that was
That's crazy. A judge has their own rules in the courtroom. You can't do everything you want to do.
yeah.
All right. Amazing. Go on.
Yeah, and I'll tell you, there were things but there are things that like most judges would let me do, and she specifically told me right off the bat, in jury selection, you're not going to ask individual jurors questions, right? You can ask them, they can raise their hand if they want to answer a question, but you're not going to targetedly ask every juror, what are you passionate about, for example, which is something that you can typically do here. But it was very easy to adjust. I just asked the group, and I only called upon those that raised their hands. And they were willing to talk to me, right? I used, Nick's great line, Nick Rowley's great line, will you talk to me? Will somebody here talk to me? And I just looked at them sincerely and I asked them, please, to talk to me. And a bunch of them did, right? And so it was not a hindrance at all. It ended up making the jury selection probably better, even though I was kind of caught off guard a few minutes before. But the whole trial went well. We had done big data on the case. And so we knew what was likely to happen in both parts of the case. And the judge appropriately broke the case down into 3 phases. So phase 1 was us against the at-fault driver. We would do an opening, presentation of evidence, closing, deliberations, verdict. And then phase 2 was against Progressive. The same thing, opening, presentation of evidence, verdict, closing, and verdict. And then if the jury was going to award punitive damages, we would have a phase 3 on punitive damages. And so that's what happened. Phase 1, we felt like we got a good jury in the case. We knew the jury that we wanted. We had done big data with the Campbells, and it was incredibly helpful. We knew exactly who we wanted on the jury and the types of folks we wanted in a variety of ways, and we felt like we had a pretty good jury to accomplish what we wanted, which turned out to be true. We also knew that we had some difficulties in the case. I'm not going to go into a lot of the things that we knew because the case is on appeal, so I'm going to kind of cut to the chase. The first part of the case, we present undisputed liability with no bad guy case against the at-fault driver that hit our client. This is the nicest guy that I have ever had on the other side in a trial. He cried on the stand, said how sorry he was, and it was clearly genuine. There was nothing fake about this guy. When we sued him and served him, he called my office, spoke to my paralegal, and said, hey, I just want you to know how sorry I am for what I did. And I hope that your client gets a really big verdict against Progressive for what they did, because he read what Progressive did in delaying payment. Anyway, so nicest guy ever, but no bad guy. And we knew that the verdict was likely to come in between 5 and 9 million against him on that part of the case, and it came in at 7, just a little above 7. And then the case against Progressive started, and that's where the battle was on. The defense attorney in that case was really tremendous. I'm not going to name drop him because I don't want his name to have to be on a podcast. But those who know, man, he was a badass. He was so good, and he made me uncomfortable the entire trial because he was just such a good attorney, very well respected guy. And they put on a great case. They put on a good case, but for Progressive, there was no overcoming what they did. And what they did is they had a system in place, and they still have this system as far as I know, but they had a system in place that came out during discovery through the deposition of their corporate rep, which was because the letter that was sent in requesting payment was not on an attorney letterhead, it got routed to an adjuster who had no training or experience at all on handling UIM claims. It went to a property damage only adjuster who had been with the company a couple of months. Not only that, they didn't even send her the letter that was sent in, and they didn't even send her the bills, which showed $855,000 in medical bills. So she had no idea what she was doing. She just knew that in their computer system, she got assigned this new claim. And so we had this case, and I asked the corporate rep, I said, hold on, so you're telling me that the exact same letter, if an attorney letterhead was slapped on it, every word the same, it would have gone to an adjuster that could have actually helped, who had training and authority to help the insured. And he's like, yeah, that's right. And like unrepentant about it, right? So you know how those clips look to the jury, during the case, during opening, and again when I had him on cross-examination. I kept that guy on cross-examination for 6 hours over 2 days as I just went through what was done. There wasn't a good moment. For every moment he was on the stand was very, very bad for Progressive. That was our point of view. And so I don't think there was any overcoming that. I think once the jury heard what he had to say, how unrepentant Progressive was about what they did, and how they frankly were just going to continue doing it, the jury just didn't find that to be okay.
What was the verdict on that phase?
Yes, $1 million for the arguably 6 or 7 month delay in payment, during which time
That was a payment of the 100,000 of underinsured.
That's right. And during that time, our client, because of their expenses and different things they had, their credit rating went from 790 to 496, right? So there was a tangible impact. And our clients had been, Hal and Sean, our clients, they had been Progressive customers for 28 years before this. And so there was some legitimate economic hardship caused, and the jury came back with a $1 million verdict against Progressive there. And then in the punitive phase, they came back with a $100 million verdict against Progressive.
Well, that's sending a message.
Yeah. And, a fair message. The amount of money is not dramatic for Progressive. I think that the jury, afterwards we talked to the jury, and there were some that felt like the message should have been higher, but not an inflamed, angry jury, just a jury that really felt Progressive did the wrong thing and that less money wouldn't have sent a message.
All right, well, we got the message sent there. So the month starts off well with verdict number 1. And tell us about verdict number 2 and trial number 2.
Yeah, so verdict number 1 is the $7 million, and then verdict number 2 is the 101, is kind of how I'm catching it, right? Because that's all. So I'm cheating with 3 verdicts, right? But it is 3. We did settle, by the way, with the carrier for the first part of that case, and that case is resolved at this point. But the Progressive case is not. Then the next trial was one. David Feingold, excellent, exceptional attorney here in my firm. He did really worked up this case well over a period of a few years. The Hahn case, Hahn v. Sanchez, and our client Lillian Hahn was just a car crash in the middle of an intersection. Both cars claimed they had the right of way, and our client had significant injuries. She had a diagnosed brain injury, but the MRI was clean. So there was nothing in the MRI that showed a brain injury. So that was a little bit of a challenge. And then she had spine issues, but nothing surgical. And so she needed future radiofrequency denervations, rhizotomies. And then she needed some additional physical therapy related to brain treatment, vestibular issues. So, and she at the time of the crash was 49, and at the time of trial was in her early 50s. And so David had worked the case up. We spent a lot of time before my first trial together. So his opening was basically ready before I did that first the trial against Progressive.
Hold on, let me interrupt you though. I got a couple questions here on this case. What was the highest offer from the insurance company on this case?
Yeah, zero. It was they never offered anything. We sent 2 offers of judgment for $25,000 at the beginning of litigation, and they rejected both. And so at that point, we honed in that, hey, this is a case we're going to try. So we're just going to go the distance on this one no matter what. So let's frame this up for trial. We're doing this. So that's what we did. And yeah, David did a great job. David and I spoke together on this frequently every month or so, reframing issues, making sure we had the right experts and everything. So that this case was well set up for trial. Yeah, he did a great job.
How did you split up the duties? Split the trial up?
Yeah, so at trial, David did the opening, David did the closing, really handled most of the witnesses, and we split voir dire 50-50. We got the defense to stipulate. We would have filed a motion in limine to split it 50-50, but the defense was okay with it. And so David did the first half of jury selection, then I did the second half. And it worked out really well. It was very, very, very smooth. And so it allowed both of us to kind of have some connection there with the jury, and allowed me to handle some of the issues that can get a little bit sticky on money without, anyway, it can be, you have to be very sensitive and delicate the way you handle it. and I've done that more. So we felt it was a good split, and it worked really well. And then David's opening, I mean, he had practiced it so many times. We'd gone over it so many times, and he just nailed it. Did a phenomenal job. Took away everything that I had.
Oh, and this is David's second trial, is that correct?
Yeah, yeah,
So you allowed him basically to be kind of be the lead trial lawyer. I mean,
yeah,
you did the opening and the closing and part of the voir dire to have the witnesses. Clearly, you were not the lead. And so, what was the result of that one?
yeah. We 13.2 was the verdict. Yeah,
That's amazing.
yeah,
That's amazing that you have a young lawyer with a second trial doing that much work. I've never heard of such a thing. And we're going to do some we got 2 case analysis scheduled prior to Vegas. And so, is one of them going to be on this case with
yeah,
David?
yeah. It is. It is. And I will say this, right? The idea that I gave this to David, no, David earned it. And if I had taken it from David, that would have been inappropriate. So he had earned it, and he did a phenomenal job in trial. So
Okay, that's kind of you to say, but I don't know any other. I know a lot of trial lawyers, and I don't know any of them that would have given a second trial this much responsibility. That's all. That's all I'm saying. You know,
okay.
what's the date we have down for this case analysis with you and David?
I think we're going to do this one on the 1st of October, I believe.
Okay, and then the one that we're going to do was it on the What's the second date we have in October for the
It's
second one?
the week, maybe the 12th. Yeah, it's the week before TLU. So, or perhaps the 14th. It's the 14th. That's the date.
That's what I said. And what's that? The 14th? Which case are we breaking down?
So I think you wanted to break down. Well, we'll either break down the progressive case, or we will break down the one. I have a trial starting the week before that will be finished in 1 week, and so
That one we're going to do live.
okay.
That one. So that one that you do the week before Vegas, because what's that one about the week before Vegas?
It's a crash, wrongful death, car crash case.
What was the highest offer on that case?
$50,000 or something. They tried to pay. It's an issue where USAA just completely left their insured out to dry and did not pay the $50,000 when they had an opportunity to in a wrongful death case. So yeah, they've suggested perhaps they'd be willing to do a number of things, but officially they've been hesitant to offer what they think the case is worth. We did a pretty high offer of judgment in the case. They requested that we extend it for like another week or something, so they could meet, and we said no, and they did not accept it. So,
What was the offer?
35 million.
That's a pretty high offer. The fact that they were considering it, I'm surprised you didn't give them a chance to reconsider. But you know what? I guess if they came with 40 right now, you might consider it. I don't know, because I know you're geared up for trial, and so got to have the trial on these things.
Well, as you know, those things, if they go to the client to decide, and they've made it very easy for us.
Got it. And so the third trial you had in that 30-day period, you did that with another one of your associates. Is that right?
Yeah. So the first trial, like I said, was broken into two verdicts, right? And that was done with Emily Cunningham, and she was just a badass. She was awesome in the whole trial. This was her very, very first trial. She literally handled half of our witnesses, including the direct examination of our medical doctor in the first phase of that, the direct examination of our claims handling expert in the case against Progressive. She just did a tremendous job. Yeah, she did awesome. Very first trial, and gets a 108 million combined verdicts. So anyway, yeah, she did.
It's pretty solid performance. It's a good way to start your career.
Yeah.
Hope it doesn't,
And she was.
hope it doesn't go downhill from here, though. I mean, it's like it's kind of setting a high bar for yourself. I'm just
Well,
saying.
well, it already did, because she was involved in David's trial, right? And so she handled a witness there and did a lot of other really tough work in that case. And we got 13 million. So for her, she had a drop off from 108 to 13. Right?
All right. Well, you know what? We all
Not
got
bad
to take
way
our
to
lumps,
start,
right? We all got to take our lumps. So we're doing Vegas October 16th through 19th here in your hometown at Caesar's Palace.
That's it.
And other than talking about this new verdict you're about to get that we're counting on, because we have a space reserved for you, you have 2 other 1-hour lectures. So tell us about what you're going to be teaching in Vegas and what benefit people will get by coming to see you.
Yeah. So the It's the journey of the trial lawyer, some of which we've talked about today, and I'm gonna walk through some of the cases and how, to overcome the lumps that you have. But I'm going to talk about really some principles that I've learned along the way to becoming an effective trial lawyer, right? Things that are super important, such as always take righteous cases only to trial and never lie to a jury, right? You you can't take a case to trial if you're going to have to hedge or be false about it. At least for me, I think that that's such a critical component to it. And if you know that you're always going to tell the jury the truth, you're able to stand in front of them with a degree of credibility that is sincere and is just, you can't do it otherwise. And so, there are things like that. You have to be authentic, right? You have to be who you are. There are techniques that great trial lawyers use that won't work for you. But guess what? If you practice a bunch, maybe down the road they will, right? And once you get some maybe other techniques in place that work for you, you can eventually get to a point where the things that might have been a stretch for you before, they're not such a stretch anymore. And you can do that, right? It is definitely the case that some people are naturally just really good as trial lawyers, that with understanding, once they know the framework of what a trial is and some basics, they're going to be kind of good right off the bat. And there are other people who are not going to be. They're going to be not very good right off the bat. But if you work hard enough and if you want it enough, you're going to get there. That's the process. Everybody's at a different place in the process, and I feel like I'm at the entry stages of doing this good work that we're doing. I think I'm 13 trials in right now into my career, and I'm, I don't know how many I'm going to do over the course of my career, but a lot, I hope. And you just keep plugging away, and you get better one trial after the next, 1 year after the next, right?
Mm-hmm. One trial at a time. So that's one of your lectures, and you have a second lecture. And what's that going to be about?
Yeah, so I'm doing a lecture on how to win like really challenging cases, right? So like, these missed cases, minor impact type of cases, and cases where, they call them gaps in treatment, right? Your client hasn't gone to treatment for a period of time, so they want to act as though that means the person wasn't injured, as opposed to they've given up on the medical systems that are there to help them, right? And how you overcome those sorts of things. And I mean, this last trial we did, $13.2 million verdict. Our client didn't go to treatment for the first time until 2 weeks after the crash. Okay, crash happens, literally goes to an urgent care for the first time 2 weeks later, then doesn't go to treatment again for 3 or 4 months after that, when she goes to a chiropractor at that point, right? Just right there, you're thinking, a lot of people are thinking, well, that's not much of a case. But there were really good reasons for that. And she was really injured. And there was a lot of evidence that she was injured. And our client was amazing at explaining what she had been through and those things. So the point is, there are some really challenging things that I think attorneys sometimes will write off as being, the end of the road on a case because they have one particularly challenging fact. And they shouldn't. No cases are perfect. Every case has issues, and you need to develop techniques to deal with the issues that come up. There are some really good techniques for all of those things. Now, almost none of the things I'm going to be saying, Dan, are going to be things that are original to me, right? I have stolen these from Claggett, from Rowley, from Mitnick, from Panish, from Rahul, right? From all of these, from David Churchill, Ben Cloward, right? Christian Morris. These are the people that have been mentors to me that I've seen, along the way. And then many other people. I mean, Zahner. I know Zahner has a big thing going on at this TLU. I took 2 or 3 things from Zahner at the last TLU that I implemented immediately into this trial that I just did.
What are those things?
So he had a much more trimmed down version because he is forced to be really, really fast in Colorado. He only has like 15 or 30 minutes to do voir dire. And when he was going through and explaining it, I'm thinking to myself, I know that there's going to be a voir dire I'm going to have where that happens to me. And so I wanted to be prepared. That's why I went to his lecture, because I'm going to have a trial probably in December where my voir dire is going to be short. But when I'm listening to him, I'm like, he just did in 2 minutes something that I take 20 minutes to do And he did it better than I do it, right? He just was amazing with that. And so then I just came into, my lab, right? My office, and I start trimming down, the way that I go through that portion of voir dire. For example, the pumpkin pie thing, right? Or the apple pie, the pie contest. Zahner does that in like 30 seconds. And I felt like the way that he did it was better than me doing it in 20 minutes. And it just, there were a few different things like that where he did things I was already doing, but I just loved the way he did it. And he did it in a way that I felt fit who I am at my core. And I was able to apply them to success. They ended up working really well for me. So yeah, so it's been a great experience, always learning from somebody who's doing something cool.
Did you make any adjustments in your rebuttal argument
Oh
based
yeah.
upon what Zahner presented? Tell us, I just had this feeling.
Yeah. Yeah. So in the rebuttal, I in the rebuttal against with Progressive, or no, the rebuttal that I did in this last one with Feingold, with Lillian Hahn's case. Zahner had talked about how he takes the man in the black suit. The man in the black suit. A lot of people are familiar with this, but the man in the black suit, he comes in, knocks on the door, and he says, "You've been chosen as someone who's going to basically be part of a human experiment, and this is what's going to happen to you tomorrow." And basically laying out all of the injuries and harm and suffering that a person is going to go through related to the crash. And it's all the things that your client has gone through, and offers money for it. And the client shuts the door. Anyway, people have heard this. I didn't do it justice just now, but Zahner just had an idea that it's better in rebuttal close than it is in regular close. And so he's been doing it that way, and he said it works really well. And so in this last trial, David did the close and I did the rebuttal close, and I took that and I used it in the rebuttal close, and it was brilliant. It worked so well. It was the closing thought before the jury came back and returned a 13.2 million verdict in a case where big data told us that we were going to get 12, by the way, on the high end. So first time we've had a case where we went over the big data estimate, but so that was
Nice
that
to
was
meet
tremendous.
Claggy's always trying to prove the data wrong. He's like, but it's always right. But apparently you proved it wrong, Kimball. You proved it wrong and you beat it. So that's good. In Vegas, I just want to mention too, besides the 9 lecture tracks that we're going to have, which I'm pretty stoked about, because this is the first time that we really had, so many great law firms doing tracks. We got Claggett and Sykes doing 3 days. We got Brian Panish, Rahul Ravapudi, and the rest of Panish and Ravapudi teaching for 3 days on how they, get their results. And then also Nick Rowley and Jacob Norman with their Trial by a Human, crew, and Dan Shaw and a bunch of other folks that are going to be teaching for 3 days. And then Joe Freed and Satch Oliver, those two guys are just rock stars, and they're teaching for 3 days. And then Campbell's, John and Elisa Campbell are doing a day and a half on jury ball. And then the rest of the tracks are, the Randy McGinns, the Dirk Vandiver, Randy Sorrells, so many great, the trial consultants have a track. Sari De Lamott's coming for the first time. Jesse Wilson, David Ball, Eric Oliver, Harry Plotkin, Sonia Chopra, Philip Miller. I'm really excited and, I guess kind of proud of the fact that all these people, decide to trust us with a platform to teach. And then on top of that, there's going to be approximately 15 workshop tracks. We just released those, today. And we got somebody like Ben Rabinowitz teaching a 1-day expert cross-examination class. I don't know if you know who Ben is, but he's such a gangster out of New York. Such a great guy, such a great teacher. Michael Cowan's doing a 1-day big rig master class on Wednesday. And then on Wednesday, too, besides all that, Clag is taking people out golfing. Zahner's taking people out to the desert to ride ATVs. Riley's taking people out on this hike and doing some yoga. So it's going to be so cool. And we got theme parties every night. I know you love theme parties. Thursday, the 80s. Friday, Halloween costume parties. Great live music. Saturday, beach party. I'm so stoked. We got almost 700 people registered now. I hope, but by the time this comes out, the room block will be closed. And we'll be most likely filled up by then because there's not that much room left. So people wait, they delay, and they're like, that delay is not good when it comes to see, Vegas in rooms because they disappear. And depending on occupancy, they really raise the rates around here. I tell you, they're
Yeah.
not sensitive, Kimball.
Right.
They get people, money. Like those hotels, sometimes they're 150 a night, sometimes they're 700 a night for the same room. It's crazy how they work around here. But
Right.
anyways, it's going to be. I am really stoked about this event, and we're only about 32 days away. So I write it on my wall every day, the date and the number of people registered, because there's a lot of pressure. We got all these people coming and putting it together and to make it all work. So it's going to be really great, Kimball. I'm glad
I'm
you're coming.
stoked, man. Yeah, it's gonna be amazing.
Is this your third one or second one
Fourth.
for Vegas?
Oh,
For Vegas,
For
though.
Vegas, it's my second. It's my second. in
Okay,
Vegas.
because you didn't make it 21 because you were in that trial.
That's right.
Got distracted, didn't realize
no.
what you were missing out. Then you caught on.
When did I miss? I don't remember, but I was in
2021.
trial. Yeah, last year. I was in trial as well. In 2023, I missed Vegas because I was in trial.
Oh, I was in New York last year, so everybody missed Vegas
Oh, okay.
last year.
Oh, okay, that's
That was a good excuse. Good excuse.
okay. Good.
So,
good.
Kimball, let me ask you, buddy. You've been at this for just a little while, and now you got your brothers joining you, which is really exciting. What, professionally speaking, what accomplishment are you most proud of?
That's a good question. I'm proud of the skill set that I've developed and kind of improving. I think as a person that has allowed me to kind of have good results up to this point professionally. I'll tell you, I'm super proud of my partnership that I have with just amazing people. That my partner Jackie and Ryan, my partner, who was brought me in and kind of trained me up and took a shot on me. I've got to say, I mean, those professional accomplishments are pretty big. Just having people that are as awesome as my partners have been, who have trusted me to do my part of this and then work together. And so anyway, yeah, I mean, the great relationship I have with my awesome partners here, Jackie Ryan, also, Josh Barrett and Ryan Loosevelt, and just the tremendous other attorneys that we have that are working here in our firm. It's the firm that we've put together. That's got to be the thing that I'm the most proud of. And
Bighorn Law.
yeah. And I'll tell you, I have mentioned Jackie a few times, and you've mentioned her, but just an absolute superstar. And it was always her dream to be a trial lawyer from the time she was a little kid. She read a novel, The Chamber, and it made her want to be a trial lawyer and to help people in trial. And in her late 20s, she developed some hearing issues, congenital, and started losing some hearing, and it made litigating and it made being in the courtroom difficult to operate as effectively as she would want to. And around the same time that was happening, I realized that I wasn't very good at leading the firm as a manager, and that Jackie was really good at managing people. And so we had been going in different directions professionally, and we kind of made a swap around 2017. And it's been just a magical partnership working together, and just seeing her do such a great job, running the firm has been awesome.
Kimball, I know that Jackie, runs the office and is in charge of, I think a lot of the pre-litigation stuff and the claims stuff that's operated there. So tell us about how your claims department at Bighorn kind of really puts you in a position to, to be a rock star in the courtroom.
Yeah, I'll tell you, I noticed years ago, I went into a trial that Egglet was doing here in town. And I saw that he had this team of really high talented people around him during the whole trial. And then I saw Sean Claggett do this trial where he just demolished Summerlin Hospital in this trial. And I saw just this incredible team of talent. And I realized that there's no way that I'm going to be able to accomplish the things that these guys are doing ever. And maybe I'll never be able to, frankly, but I certainly wouldn't have a chance if I didn't have a team that was really exceptional around me to do it. And that's really what makes everything work. So even in trial, right, I have an unbelievable paralegal, Amy Savetovich. She's incredible. But the prior paralegal I had, Erickson Finch, he's director of litigation in our firm. He runs operations in our firm. Jackie is the CEO. We have Rhonda. Anyway, we have this team of people that are leading the firm that make it all possible. And in claims, it has to be done right from the beginning. These cases have to be done right early on, or the risk goes up exponentially at trial. And so, yeah, so Jackie runs claims.
When you say done right, what do you mean by that? Because I think everybody probably thinks they do their claims right and they're writing things right. But what do you mean by done right? And what are the mistakes that people make that, that would prevent the results from happening that you're getting?
I think number one, make sure that your clients are doing things that are reasonable and not things that are stupid. If they're seriously hurt, they should be following their doctor's directives, right? Not attorney-guided care or anything like that. But their doctors, if they're recommending things and you have your clients who aren't following their doctor's orders, that's a problem. And you need to be in tune enough with where your clients are and what the doctors are saying to do that. But when it comes fundamentally, I think fundamentally what you're getting at, Dan, is wherever you are, you need to understand the insurance laws where you are. You need to understand that really, really well. And then you need to make sure that you are appropriately sending the demands at the right time with the right pressure points so that the case either resolves, or if the insurance company plays games with you, you have created an opportunity to seriously punish them for playing games. And then you carry it out. You actually do punish them for playing games. That is critical. And so the language of your demands is so important. The timing of your demands, the opportunity to settle, so critical. And that's really what it is. That's fundamentally, I've been able to take cases that under normal circumstances, 99% of law firms out there would have been in a situation where they get paid $25, $50, or $100,000. And instead, my clients are receiving millions of dollars on those cases because the insurance company decided to play games. And we were happy to let them play games if that's what they wanted to do. And we made sure they paid for it.
It's pay to play at Bighorn Law.
It is, yeah.
That's a good one. Pay to play at Bighorn Law. All right, Kimball Jones. I think that's going to take care of our time here together. Glad that you're in the same town I am. And
likewise, dude. I appreciate you, brother. Hey, I just, I appreciate you, Dan. You've done a lot. You've really helped me along the way, man. Thank you.
Well, thanks. And I look forward to working more with your brothers. We get back to our regular scheduled workshops here in town, and I'm so excited. Like, I think it's so cool, like, to have your older brothers come join your firm and really start their careers, and you get to guide them along the way and, give them advice, as a younger brother, but to really, help them go from, rookie lawyer to trial lawyer in just a couple of years and not have to be a 20-year journey. So I think that's just so cool. So
yeah,
look forward to it all. I will see you soon, definitely before Vegas, maybe later this week, because we have a boot camp starting tomorrow with a bunch of folks coming from out of town. I'm real stoked about it. Kimball almost did my boot camp once, but he decided he doesn't like to memorize stuff. He's a very difficult student. Took away a few things from it. Hopefully we can convince him that it's okay to practice this method, my connection skills methodology, but that's okay.
Look, I learned some great stuff from you, Dan, and it's an interesting world. There are people who learn in different ways, and I'm one of those guys that I learn everything in a lecture style, and then I play it in my head a million times. I don't know, man. I'm a weird guy that way, but man, you have a badass boot camp, and you've done really good work, and I learned a bunch of stuff. I mean, I've probably been there 20, 30 hours in boot camp stuff.
Probably.
Right. So yeah, I've learned a ton of good stuff, brother.
One thing for sure is just to have a little nicer tone at the beginning of cross-examination.
Yeah.
We're getting a little aggressive, right? I mean, just working at it constantly, but at least that was good. I remember that. It was a good reminder. So at least just be mindful of it. Whatever tone you want or whatever demeanor, be intentional. That's going to be my last word with you, Kimball Jones. So you have yourself a great day, and we'll see you soon.
Thank you, Dan.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.